Hello, Judge Gossett.
Good afternoon, everyone. I apologize for being a little late. I was having some technical difficulties, believe it or not.
Afternoon, Judge.
Good afternoon, Clay.
All right. I think looks like, all right, Mr. Elkins is, Mr. Newman and Mr. Elkins. There's Mr. Elkins, okay.
Hello.
And Mr. Chad Newman,
Yes, sir.
I believe Mr. Newman, you were muted, okay. Mr. Newman, you are, Mr. Newman, can you hear us?
Yes, sir, I can.
Okay.
Oh, and then we have,
Yeah, okay, I see. We got two. All right. Now, very good.
there's
Now,
Mr. Taylor, Judge.
okay, and the one on the bottom is muted. Okay, we'll call number 2023. All right. I note also, is Mr. Holmes supposed to join us today? He was added as an ad litem this morning.
No, sir, I do not believe so.
Okay. All right, this calls number 2023-146. Capricia Norris and Jacoby Norris versus Bagley's Power Equipment LLC and Jason. All right. And this is a motion for approval. And so the moving parties, who's the moving party in this matter?
Your Honor, I'm Chad Newman. I represent minor Hunter Taylor. His father, David Taylor, is here. We're plaintiffs in intervention in this case.
All right.
I'm getting a lot of static.
Okay.
I have to.
All right. Mr. Newman, if you'll speak again, please.
Yes, I'm trying to make sure everyone can hear me.
Yeah, when
Chad,
you get closer, we can hear you better. Okay, very good.
the close-up. Chad Newman for the plaintiff, Hunter Taylor, his father, David Taylor, plaintiffs in intervention in this case.
All right. Ms. Henry.
Miss Henry, on behalf of Germania Insurance.
All right. Matthew Milam, I'm going around the screen.
Yes, Your Honor. Matthew Milam and Randy Roberts on behalf of Lucretia Norris as next friend of plaintiff Jacoby Norris.
All right. Clay Wilder.
Your Honor, I'm here on behalf of the minor child, Hunter Taylor.
You're breaking in and out too, so be careful. Yeah.
Judge, again, for the record, I'm here on behalf of the minor child as the ad litem appointed by the court. The child is Hunter Taylor.
All right. Mr. Kent, Jared Kent.
Yes, Your Honor. Jared Kent here on behalf of the defendant, Andy Spiller.
Vernon Elkins.
Yes, Your Honor. Vernon Elkins here for defendant Bagley's Power Equipment LLC.
All right. And Randy Roberts, you and Matthew Milam together, correct?
Yes, Your Honor.
All right. And Mr. Taylor, is that Mr. Taylor joining us?
Yes, sir.
Very good. All right. All right, Mr. Newman, you may proceed.
Your Honor, David Taylor, the adult parent and guardian of the minor child, needs to be sworn in and to testify.
All right, if you'll raise your right hand, sir. You do solemnly swear, promise, or affirm the testimony you give in the case pending before the court speaks the truth, whole truth, and nothing but the truth, so help you God. And you're muted, Mr. Taylor. They need to unmute. And ladies and gentlemen, I apologize. I'm in my shirt sleeves. Our air conditioner is out in the courtroom, third floor. So y'all apologize for that. All right, you may proceed, Mr. Newman.
Thank you, Your Honor. Mr. Taylor, would you please state your full name for the record?
David Stewart Taylor.
Mr. Taylor, will you tell the court where you live, please?
Tatum, Texas.
What is your address there in Tatum?
15078 FM 782 North, Henderson, Texas 75652.
Is it correct that you are the natural father and guardian of Hunter Taylor?
Yes, sir.
On June 19th, 2023, you, your wife Clarissa, and your son Hunter were involved in a motor vehicle collision on State Highway 149 in Gregg County, Texas. Is that correct?
Yes, sir.
You were injured in that collision, isn't that correct?
Yes, sir.
And your wife Clarissa was also injured in that collision. Is that correct?
Yes, sir.
And your son Hunter was injured in that collision. Is that correct?
Yes, sir.
In fact, as far as you know, everyone involved in that collision, a 3-car collision, there were serious injuries arising from that collision. Is that correct?
Yes, sir.
Do you understand that on behalf of you, Clarissa, and Hunter, a petition for intervention was filed in an already existing lawsuit against Bagley's Power Equipment LLC and Jason Andrew Spiller, the other driver who purportedly contributed to the collision, and that suit was filed in the 4th Judicial District Court in and for Rusk County, Texas. Is that correct?
Yes, sir.
A settlement agreement has been reached between you, Clarissa, and the defendants for your individual personal injuries. Is that correct?
Yes, sir.
Additionally, your underinsured motorist carrier, Germania, has agreed to pay its underinsured motorist coverage policy limits on Hunter's behalf. Is that correct?
Yes, sir.
You understand that we're here today to seek the court's approval of the settlement which we have reached with the defendants and Germania on Hunter's behalf?
Yes, sir.
You've had a chance to look down the settlement breakdown for all of the money going to Hunter in this case. Is that correct?
Yes, sir.
You understand that Federated and Progressive Insurance have agreed to pay $60,000 on behalf of their insureds to the benefit of your son, Hunter Taylor. Is that correct?
Yes, sir.
You also understand that Germania has agreed to pay its policy limits of $100,000 to the benefit of Hunter Taylor. Is that correct?
Yes, sir.
You understand that as your attorney, I have incurred some expenses in prosecuting Hunter's claims. Is that correct?
Yes, sir.
And that amount is $2,133.82. Is that correct?
Yes, sir.
You also understand that I have waived any attorney's fee in Hunter's case. Is that correct?
Yes, sir.
You also understand that Hunter does have some outstanding medical bills incurred on his behalf, including Christus Good Shepherd Medical Center to the amount of $14,251. Is that correct?
Yes, sir.
Christus Trinity Clinic has an outstanding balance of $4,831. Is that correct?
Yes, sir.
And then Acute Care Specialists has an outstanding balance of $1,745 incurred on Hunter's behalf. Is that correct?
Yes, sir.
You also understand that Blue Cross Blue Shield's Healthcare Plan of Georgia has a subrogation lien in the amount of $22,903.55. Is that correct?
Yes, sir.
And you understand that all of those amounts outstanding must be paid from the settlement proceeds intended for Hunter's benefit. Is that correct?
Yes, sir.
So that the final amount that Hunter is set to receive following the payment of all attorney's expenses, as well as medical expenses and subrogation interests, amounts to $114,135.63. Is that correct?
Yes, sir.
You have agreed and recommend to the court that this amount of money intended for Hunter's benefit be placed into a structured settlement. Is that correct?
Yes, sir.
And you've had an opportunity to look over various options for structured settlements on Hunter's behalf. Is that correct?
Yes, sir.
And you have selected one that you believe is in Hunter's best interest. Is that also correct?
Yes, sir.
You understand that if the judge approves this settlement, this will be all of the money that can be received from these defendants as a result of this collision for the benefit of your son, Hunter Taylor.
Yes, sir.
You understand that if the matter were to proceed to trial, a jury may award more money, less money, or no money at all. Do you understand that?
Yes, sir.
Do you believe it's in your son's best interest to accept the settlement amounts as offered? Is that correct?
Yes, sir.
Do you agree that no one is forcing you to accept these sums of money on Hunter's behalf, that you made this decision on your own after consultation with me as your attorney?
Yes, sir.
You understand that the court has appointed a local attorney named Clay Wilder to act as an officer of the court on Hunter's behalf.
Yes, sir.
And you've had opportunity to meet with Mr. Wilder, haven't you?
Yes, sir.
Okay. In terms of Hunter's injuries, has Hunter made a good recovery from those injuries?
Yes, sir.
Do you believe that this settlement is in Hunter's best interest?
Yes, sir.
All right. Your Honor, I will pass the witness to whomever needs to talk to Mr. Taylor next.
All right. Ms. Henry, do you have any questions?
Just a few, Your Honor.
All
Hi, Mr. Taylor. I'm Diana Henry on behalf of Germania Insurance. I just have a few follow-up questions for you. You understand, like Mr. Newman mentioned, we're here for settlement, and you're asking the court to settle this case is for Hunter Taylor. Is that correct?
Yes, sir.
And you understand that as a result of this incident, all the money that Hunter receives today is part of that settlement, correct?
Yes.
And that you understand that if the court approves the proposed settlement agreement with respect to Hunter Taylor, that you or Hunter Taylor cannot come back to Germania and ask for more money, that you've exhausted your claims. Is that correct?
Yes.
Okay. And that's all I have, Your Honor. Pass the witness.
Mr. Kent?
No questions, Your Honor.
All right. Mr. Elkins, do you have any questions?
No, I don't, Your Honor. Thank you.
Mr. Wilder?
Yes, Your Honor, just a few. Mr. Taylor, tell the court just briefly the nature of Hunter's injuries.
He snapped both arms on both bones, had a fractured pelvis, and I think that's all he had.
And he lives with you in your home.
Yes, sir.
So you would be certainly one qualified to tell the court what progress he's made and what level of recovery he has achieved. Is that accurate?
Yes, sir.
And do you think Hunter has healed from his injuries sustained in this accident?
Yes, sir.
Is he currently under the care of any doctors or receiving any treatment for the accident?
No, sir.
We've gone over some numbers here that shows there was a Blue Cross Blue Shield claim made back for some of Hunter's treatment. Is he still covered under that policy?
No, sir.
Is he covered under any policy of health insurance now?
Yes, sir. He's under Medicare or Medicaid, whichever one that the government approves for minor children.
So if something were to develop where he needed some follow-up care, you do have that protection.
Yes, sir. We have insurance for him.
All right. Now, as far as this structure is concerned, and when you and I met with your wife and with Hunter, we talked about securing these numbers, and we've done that. We've gotten them to you, and you've picked what the structure group labeled as option number 4. Is that correct?
Yes, sir.
And this information has been provided to the different defendants in the cause, and if the court approves this settlement and this option 4, the manner in which to handle Hunter's money, do you understand that that will become an order of this court? That is how the money is to be invested and paid.
Yes, sir.
There's an allocation of $10,000 upfront in cash to be held out of Hunter's money. Now, you understand he's still a minor child and can't receive that money outright, correct?
Yes, sir.
How old is Hunter?
He's 13.
Sir?
He's 13.
Judge, I'm sorry, I lost everybody.
Mr. Wilder, can you hear
He's
me?
13 today.
He's 13 still. Yes, sir.
I hear you now, Judge. I'm just in and out, and I'm losing Mr. Newman. Okay. You realize then, sir, there'll have to be some provisions made for putting that first $10,000 up for him until he's 18.
Yes.
I'm not sure we're getting through, Judge.
I can
Is that
hear.
a yes, Mr. Taylor?
Mr. Taylor, can you hear Mr. Wilder?
Yes, sir.
All right. All right. Mr. Taylor, Mr. Wilder shake your head, yes, or no, Mr. Taylor. All right.
Okay. All right, we'll try it again. Well, the point, Mr. Taylor, is that until he reaches 18, that money will be restricted for him. And then beyond that, option 4 and the different mechanisms of payment, that will be a part of the order, and he will receive those monies in those amounts on those dates. And that will be the order of this court going forward. Do you understand that?
Yes, sir.
It's not an investment program where you or his mom could go in and withdraw these funds or change any of these payment schedules. This will be the order of the court if it's approved today going forward until his final payment at age 25, which would be roughly 12 years from now. You understand that?
Yes, sir.
All right. And you've seen how the money grows over that period of time, and it pays actually more than was invested, and actually does achieve a higher financial benefit for your child. And is that one of the reasons, at least, that you've picked option 4?
Yes, sir. We're just trying to look out the best for our son.
All right. And these are some things that you and your wife told me from our first meeting that were important to you, that you wanted to provide for some payment and some structure going forward. Do you feel like option 4 has satisfied that?
Yes, sir.
And are you asking the court, if this matter is approved today, to incorporate the payment schedule contained in option 4 as a part of the court's order?
Yes, sir.
You think that's in the best interest of your son?
Yes, sir.
I pass this witness, Your Honor.
All right. Mr.
Thank
Roberts,
you.
Mr. Roberts or Mr. Milam, did y'all have anything to add?
We have nothing to add, Your Honor.
All right. Anything further? You're muted, Mr. Newman, but I know.
No, sir, nothing further.
All right. Anything from any other parties other than the ad litem?
Nothing further, Your Honor.
No, Your Honor.
No, Your Honor.
Nothing further, Your Honor.
All right, Mr. Wilder, I'll ask for the recommendation of that ad litem.
Your Honor, it's my recommendation that the settlement as presented to the court be approved, which includes option number 4, a Pacific Life Insurance Company structure plan secured by Paul Christianick and his settlement group. This payment schedule has been submitted to all counsel, and I understand that everyone else is okay with it, subject to the court's approval. I have met with Hunter personally, and I've met with his family, and I concur with his dad that under the circumstances, this is the best thing for him. I've been in his presence and I've interviewed him, so I know his level of health and his level of recovery appear to be consistent with his dad's testimony. He was not under the care of a doctor when I saw him a month or so ago, and he's still not. So I'm taking that to mean dealing with. So I would recommend this to the court, Your Honor, and I would also advise the court that there's been an agreement on the ad litem fee of $7,500.
All right, the court finds a proposed settlement, which specifically option number 4 as set forth to the court is just, fair, and equitable, and in the best interest of the child. And the court will approve the same and will approve the ad litem fee of $7,500.
Your Honor, would the court wish for me to email the e-file option 4 or present it to the court in person just so you would have it, or that we didn't actually testify to all the actual terms, I'm happy to provide a copy to the court.
Yes, please.
I will do that, Judge.
Either method will be fine. All right. All right. Thank you, ladies and gentlemen. Appreciate everybody's cooperation. And I'll further note that I didn't say this, but this is broadcast over YouTube in order to comply with the open course docket. All right. Everybody, thank you so much. We'll stand in recess.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.